Hello, my name is Jerome Aguilar, and I will be discussing employment discrimination today. So, the question we must ask is, what is employment discrimination? It is a form of discrimination by employers based on race, religion, gender, national origin, or physical or mental disability. Discriminatory practices are bias in hiring, promotion, job assignment, termination, compensation, retaliation, and various types of harassment. Protection from discrimination. The Fifth Amendment protects individuals from deprivation of life, liberty, and property without due process. Equal protection of all laws is guaranteed for every individual by the Fifth Amendment. Okay, so let's read it. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia where in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of the law. In our case, that is what we're referring to. Protection also is in the 14th Amendment, which protects states from preventing individuals of due process and equal protection. The Constitution does not directly state protection against discrimination, but more so states an individual's rights to equality as well as fair treatment. Looking at Amendment 14, Section 1, all persons born or naturalized in the United States and subject to the jurisdiction of are citizens of the U.S. and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny any person within its jurisdiction the equal protection of those laws. Now we will look at the EEOC, which is the U.S. Equal Employment Opportunity Commission, and they enforce federal laws that make it illegal for an employer to discriminate against race, color, religion, sex, age, national origin, or disability. The EEOC also protects employees who have complained, filed, or taken part in any discrimination lawsuit. Employers with at least 15 employees, labor unions, and employment agencies are all covered by the EEOC and federal law. They have the authority to investigate charges of discrimination of employers who are covered by the law. And we'll go over some examples now. Title VII of the Civil Rights Act of 1964. This is the one that we will be looking at most, and you'll see them in examples of cases later on. This act prohibited employers with more than 15 employees from discriminating against race, color, religion, sex, or national origin. The act made it illegal for employers to discriminate in relation to hiring, discharging, compensating, or providing the terms, conditions, and privileges of employment. Employment agencies may not discriminate while hiring or referring, and it also prohibits labor organizations from discrimination. Moving on to Equal Pay Act, it prohibits employers and unions from paying different wages based on sex. So it provides that if workers give equal effort, work, and responsibilities under similar conditions, they should be paid equally. Now the ADEA, which is the Age Discrimination Employment Act, it prohibits employers from discrimination based on age, and this is mostly concerned with 40 and up. Benefit, pension, and retirement plan guidelines are contained in this act. Disparate impact claims filed under the ADEA require proof of motive for a violation, and employees of all legal work ages are protected by the ADEA. Moving on to the American with Disabilities Act. This act eliminates discrimination against handicaps. It provides discrimination based on physical or mental disabilities within interstate commerce and state governments. This act is more broad than the Title VII Act, and we'll explore why in the examples of the cases. USERRA, the Uniform Service Employment and Reemployment Rights Act, prevents employees from discriminating against an employee based on his or her military services. This act basically keeps employers from denying employment, reemployment, retention, promotion, or benefits to employees previously, currently, or who will have obligations to the military and services. Now we will look over 3 cases that I found interesting. The first one is Griggs versus Duke Power Company. In this case, after the Civil Rights Act of 1964 was passed, Duke Power required that their employees to have a high school diploma or a minimum score on a provided IQ test. It was determined that African American applicants were selected at a much lower rate compared to white American candidates. The court found that if the IQ test disparately impacted the ethnic groups, the business must prove how the tests are related to the jobs in which the tests are required. Title VII of the Civil Rights Act prohibits tests that are not a reasonable measure of job performance. Continuing on, the court found that the aptitude test and also requirement of a high school diploma were not directly related to the jobs, making Duke Power Company's employee transfer procedure a violation of Title VII of the Civil Rights Act of 1964. Moving on to the next example, Cleveland Board of Education versus LaFleur. Carol Jo LaFleur, a middle school teacher at Patrick Henry Junior High School in Cleveland, Ohio, was forced to discontinue her duties as a teacher on March 12, 1971, due to the Cleveland Education Board's requirement of a pregnant teacher to take 5 months leave without pay. And under this case, they must notify them after, I believe it was 4 months of pregnancy. Other requirements were no return for the teacher until the next semester, with proof of the child being 3 months old and a doctor's note of good health for the mother. And also, they were required, they weren't guaranteed their jobs back. They were put above every other applicant to be reviewed, but they were not guaranteed their job back. Anna Elizabeth Nelson, who is also a teacher in Cleveland, was also forced to take leave. They filed separately. The two cases filed separately, separate suits in the district court challenging the Board of Education's rule. The cases were tried together in the district court, and the court found that the board's policies were constitutional. As the case moved on from the Sixth Court of Appeals, the decision was reversed, concluding that the 14th Amendment Equal Protection Clause was violated by the board's policies. And Justice Potter Stewart led to the court's conclusion that it was unconstitutional to require teachers to stop teaching after the 5th month of pregnancy, stating that it is a personal choice as long as they are physically capable of doing so. Going on, Justice Stewart also pushed for a decision that the restriction based on the age of a newborn child violates the Due Process Clause because the board could not prove how the requirement relates to the required job. Now, the last case, Onkel versus Sundowner Offshore Services Incorporated. Joseph Onkel filed a complaint against Sundowner, claiming he was harassed by his coworkers of the same sex in the workplace, which is a violation of Title VII of the Civil Rights Act, is what he claimed. The case was moved from district to Supreme Court, which granted certiorari, which is the higher courts going over the ruling of lower court. After review, the court unanimously ruled in favor of the violation of Title VII, being that it is not limited to discrimination of the opposite sex, being that it places the victim in a disadvantaged working condition. Okay, so in conclusion, what we have learned, we discussed Title VII multiple times. So Title VII of the Civil Rights Act of 1964 plays the biggest role in protection against employment discrimination, as it has been used in most cases. Within the second example, the second case, we found the pregnancy case, and I said what I learned is pregnancy is included under sex employment discrimination as part of a woman's choice to work up until labor or until she is incapable of doing so. She is also entitled to returning to her position when she is capable of doing so. as shown in that case where they reversed that ruling. Employers must show their requirements are related to the job they are hiring for. So that goes back to the first case where those IQ tests were not related to the job. And the last thing I said is the employment discrimination is covered and enforced by the EEOC. Everyone of working age is entitled to these laws. And like I said, most cases are 40 and over. Alrighty, so that is it for me. We've gone over employment discrimination. Have a great day.